It's not possible. I didn't say it would be easy, Neo.
Still looking for a plea sheet.
I have a copy of it.
Oh, I see. It's a different version than what we normally use, and I didn't realize it was under here. Because the advice to rights is double-sided. You know, we usually use double-sided in our court files. I think that's even in the court files. Okay. What are the possible penalties for the plea offense?
Oh, the plea, the misdemeanor is a 90-day misdemeanor.
It's a 90-day and or
$500.
$500. Mr. EnemyoftheStateTv, is that your understanding as well?
It is. Excuse me. It is, Your Honor.
So the other thing that's just specific to our court, that's weird, is if we keep it here, we amend the count, we don't add the count.
Okay.
I don't know. It's our clerks. So if it stays in district court, we amend the count. If we send it to circuit court, we add a count.
The amended count one.
Yeah. So I'm going to change it on here as well. Just going to put one amended. As amended. I got it. On the record in State of Michigan versus Carmen Fahey, 2401163FY.
Good morning, Your Honor. Alex Peterson on behalf of the people, P80971.
Good morning, Your Honor. Takura Nyamfukuza on behalf of Carmen Foy, who is present and standing to my left.
And you are Carmen Fahey?
Boy.
Boy.
Irish and Gaelic.
Okay. Thank you. Today is the date for preliminary exam, but I received a plea agreement. This says that the Attorney General's office is offering a misdemeanor welfare fraud, failure to inform 500 or less in lieu of the original charge. Further, a delayed sentence. It does not say how long the delayed sentence is to be, but delayed sentence under 771.1 with terms and conditions, of which I guess I get to pick the terms and conditions since the only one mentioned here is restitution. No upfront jail, dismissal upon completion of the delayed sentence. I think that's what I have. Is that a full statement of the offer?
That's correct, Your Honor.
It is, Your Honor, and I know we haven't reached that juncture yet, but I think even, or perhaps not today, but within a week or so, we are in a position to pay off the restitution. So just wanted the court to be aware of that.
Okay. And Ms. Foy, this is an offer you're interested in taking today?
Yes, Your Honor.
Okay. Welfare fraud, failure to inform is a misdemeanor punishable by up to 90 days in jail and or $500 in fines plus court costs, restitution, and misdemeanors can carry up to 2 years of probation. You understand the possible penalties?
Yes, Your Honor.
Some criminal convictions can have other consequences. If you are a citizen, foreign travel may be restricted. If you're not a citizen, you may be removed from the country, excluded from admission to the country, or denied naturalization as a citizen. You have an agreement to delayed sentence. Delayed sentence is a maximum of up to 1 year under MCL 771.1. And the agreement is so long as you satisfy, I guess, terms and conditions, kind of vague, the case is dismissed. If you are unable or do not satisfy those conditions, the charge would, of course, stay on your record, and then you'd ultimately be sentenced on the charge at that time. Is that your understanding how this is going to work?
Yes, Your Honor.
You have the right to have an attorney in this matter. Mr. EnemyoftheStateTv is representing you. You have the right to a trial. That could be by jury. Did you have an opportunity to review an advice to rights and plea information?
Yes, Your Honor.
And you signed this document?
Yes, Your Honor.
Have you had the chance to ask your counsel all your questions?
Yes, Your Honor.
Do you understand that if you proceed with pleading guilty, you'll give up each one of these rights? There will not be a trial of any kind.
Yes, Your Honor.
If you were on probation, parole, or bond on the day this occurred, pleading guilty could result in a probation, parole, or bond violation. As a result of that, you could receive a consecutive sentence for your probation, parole, or bond violation. Are you ready to proceed with your plea?
Yes, Your Honor.
Raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth under penalty of perjury?
Yes, Your Honor.
We're going to proceed with the factual basis. It's going to be a little bit,
Pardon the interruption. If the court will allow, I think I could do that pretty.
so based on a discussion with the chief judge of the circuit court, I believe I have to attempt it myself first before I can turn it over to counsel.
Yes.
Okay. Ms. Foy, between the dates of June 6, 2021 and April 9, 2022, were you receiving, I guess, a public benefit?
Yes, Your Honor.
What was that benefit?
Daycare.
Like a supplement that helps you pay for daycare? Is that what
Okay,
it was?
yes.
Well, that's what I'm asking, because you said it says that you're agreeing that there's some kind of,
Over issuance. Yes,
pardon?
yes.
I didn't understand the word.
Oh,
Separate.
an over issuance of benefits.
Over issuance. So I'm asking, you were receiving a benefit.
Yes,
You're saying that benefit was related to daycare.
yes.
Okay. And then what happened with your daycare benefit that makes you guilty?
It stayed open longer than it should have.
Well, how so? Did your income increase, making you ineligible for that benefit, or you no longer needed to put the child in as much daycare because you weren't working as much?
It was COVID and at times she was home with me, but the daycare case stayed open longer than it should have because I adopted her in August of 2020.
Okay. So
So
then she wasn't going to daycare because of COVID, is what you're saying?
But the case was still open.
Sure. Answer my question.
Okay.
She wasn't going to daycare because of COVID.
No, not till,
She was staying home with you.
yes.
Okay. But then did you receive some kind of benefit as a result of that case being open?
The daycare provider was paid even though it was closed because the case was still open and it was COVID. She did go back to daycare in April 2021.
Mm-hmm. So you're saying you yourself did not receive the benefit the daycare provider did?
But if the daycare had been open, I would have received the benefit and the case was not closed. It was still open.
Sure. I'm asking who profited from this failure to this leaving the case open when it wasn't being a service being used. And you're saying the daycare profited, not you.
But when she went back in April, I profited.
Meaning they said you have a credit on your account?
No, they just billed and she was there in April.
I don't understand how that means you profited. Then you're receiving a service and they're being paid for that service.
I guess when, to my understanding, during COVID, even though daycare was closed, daycare providers were allowed to be paid to keep that service open when the pandemic was over.
Okay, how does that mean that you've committed a crime?
Yeah.
Yes.
Ms. Foyle, on the 12th of August in 2020, did you in fact adopt Vivian Green?
Yes.
Yeah. And at the time, were you an administrative law judge here in the state of Michigan?
Yes.
Because of your position, before the 12th of August, did you qualify for the child development and care benefits for Vivian because she was a foster child?
Yes.
And because she was a foster child, that was the only reason that you were receiving that benefit.
Yes.
And after the 12th of August in 2020, did you submit a form to the Department of Health and Human Services called a redetermination?
Application. Yes.
And on that redetermination, if it had been stated explicitly that you had adopted her and she was no longer a foster care child, you agree that you would not have continued to receive that child development and care, shortened to CDC benefit.
Yes.
So in fact, the Department of Health and Human Services relied on that redetermination that you submitted after Vivian had been adopted to continue paying that child care development benefit.
Yes,
And was the amount $499.99 or less?
Per what? Total?
Total, yes.
Wow.
I think that for the misdemeanor, the amount is $500, Your Honor.
Sure, but of course, as you well know, the factual basis can be to the original charge, and I don't want her to misrepresent the facts of the case to try and squeeze it in the misdemeanor because she's under oath.
Okay.
So we should give honest testimony.
Yes. Would you agree that it was more than $500?
yes,
Okay, so to be clear then, once you adopted and you did the redetermination, you failed to disclose that she was adopted.
Yes.
Okay. And then as a result of that, the benefit kept getting paid to the provider.
yes,
And then there came a point where you started to even use the provider and the benefit was paid on your behalf.
yes,
Okay, so there was a time where not just the daycare was getting paid while she was at home with you, but they continued to pay once you used the service
Yes.
based on not knowing that she had been adopted.
yes.
I see. Okay. Anything else on the factual basis?
Just one question, for Ms. Fay. Was the amount that was, overissued, $6,741?
Yes, according to the department, yes.
I have nothing further.
When you submitted that redetermination, you obviously knew you had adopted your child.
What I will say is that when I was fostering my daughter, she was very sick. And so, but it was like a village. The foster care worker, the CPS worker, the daycare worker, the Medicaid worker, they all helped me because I was at U of M, still trying to work full time. I was still traveling for work, so it was a lot. And so,
So I am trying to get the last of the factual basis. I'm not
Okay.
trying to get your mitigating circumstances.
okay, yes.
Okay. So you knew you'd adopted and you knew you had failed to disclose that?
I didn't read the redetermination. She normally filled it out for me and I just signed it and I was overwhelmed and I didn't read it.
Okay.
So I just signed it and sent it back and it still had foster care worker, foster child on it, and I did not notice.
You signed that document?
Yes, I did. So,
And so you should have known.
and I should have read it.
That it
Yes.
was not accurate information.
Yes, and I did not notice. Yes,
And you probably also should have known that you weren't going to qualify for that benefit anymore.
I did know.
And so when you continued to receive that benefit, you should have known you shouldn't have been getting it.
Well, yes. What I would say is that, even though she was adopted in April, it continued for a time after, and I didn't know when it ended. But it would end because I wasn't eligible because of my income,
Right.
and it did continue.
Sounds like for a while.
Yes.
Anything else from council?
No, Your Honor.
No.
All right, I think we had to make sure we had the mens rea in the
Okay.
record because this isn't a strict liability offense. It has to be with intent to defraud. Although Ms. Fahey or Ms. Foy has tried to sort of put that this is accidental into the record.
Oh, no, that was not my intention. I'm sorry.
And of course, there has to be intent to defraud.
It is.
Mr. Nyamfakudza, are you satisfied that your client has provided a factual basis that includes all of the elements, which include the mens rea necessary for this?
Yes, mens rea and actus reus, yes.
Ms. Foy, did anyone make any promises or threats to you other than this plea agreement to get you to plead guilty today?
No, Your Honor.
Are you pleading guilty of your own free choice?
Yes, Your Honor.
Then to an amended count one, the misdemeanor welfare fraud failure to inform, 500 or less, how do you plead?
Guilty, Your Honor.
And your guilty plea to be knowingly, voluntarily, accurately made with sufficient facts on the record upon which to base your plea, it's therefore accepted. I don't think that we have a crime victim rights issue in this case, so I can proceed with the immediate delayed sentence if the parties are amenable to that. If you prefer I set a date, I can do that.
People are fine with proceeding right now.
Likewise.
All right. On behalf of the state of Michigan, go ahead for sentence.
But we would just ask that Your Honor follow the plea agreement in this case, specifically with the restitution amount of $6,741 and 45 cents pursuant to the delayed sentence statute.
Let me ask you this, though. You contemplated that there's going to be compliance with some acts to earn a dismissal. And I want to know what things you contemplated that would be done aside from paying restitution. Because the sentence could be delayed up to a year. I imagine if Ms. Foy can pay the money and get a dismissal and that's all you wanted, we could have just adjourned this another week. She would have paid the money and we wouldn't have even taken the plea. So.
So that is correct, Your Honor, and I do apologize for any confusion. I know every court is a little bit different, so I just tend to include that language if the court wants to impose any other conditions, but our main concern here is the restitution repayment. So if we need to come back in a week or so and I can discuss it, then that's
I guess I'm confused about why did we go through the exercise of having Ms. Foy plead guilty if all you're trying to do is collect restitution and she's saying she'll have it in a week? Is it because if she would have paid it today or yesterday, you probably would have dismissed if that's your goal in the end is get the money and dismiss. So I'm confused about why we took a plea today if she's going to pay the money next week and we dismiss the case next week. Why would we have gone through this exercise? So I'm trying to figure out what else we're trying to do here.
So I wasn't sure she was going to be able to pay it in a week. I wanted to give her the probationary period to pay it all. I didn't know it was going to happen so quickly. And that was the intent behind the plea today.
So you just weren't confident that even though she said she had the money within a week, that it would happen within a week.
That's correct.
Okay. Mr. Neofakutsa for sentencing.
I would ask the court to follow the agreement, and I don't believe the court has any reason to believe that Ms. Foy will end up in front of a court for any other reason. She is an active member of the community. I won't go through the many lists of organizations and things she's done to benefit this community. And when she speaks about the village, I know that, matter of fact, I was one of the people that she mentored when I was in law school. And I don't think this is something, the sort of thing a court can take judicial notice of. But again, Ms. Foy is a very active member of the community. And given that, again, we don't have a crime rights victims issue here, I just ask that we be allowed the shortest amount of time and have this dismissed pursuant to the agreement.
The other thing that just occurred to me is, don't you both now have an affirmative obligation to report this plea to the state bar?
Yes, we do.
I believe you do. So that's the other part about this. So we went through this exercise and the state bar will be informed, which may or may be the appropriate outcome based on the nature of the incident. I don't know. Okay. Ms. Foy, anything else you want to tell me to consider for sentence today?
No.
The other part, of course, is as I've taken a plea, there will be mandatory assessments that I will have to make. There will be the restitution, of course, which apparently is agreed to be $6,741.45. Counsel, there are those forms in front of you underneath the plea sheets. We need that filled out as best you can so that we know where to send the restitution money.
Okay.
So they want to know where they have to actually send it.
Okay.
Because now it's through the court, the money goes through the court. $75 crime victim rights fee, $50 state minimum costs. $100 fine. $6,966.45. We'll set this on the calendar for 60 days out for the deadline of the delayed sentence to have the dismissal. The only other conditions of your delayed sentence are the typical, when you're under supervision of the court, don't leave the state without notifying us. Don't commit any crimes.
To that point, we had a travel request submitted from Ms. Foy to go to Alabama on a trip with her daughter for an NAACP educational experience, and we would ask that the court grant that because her daughter is too young to travel on her own.
Not filling out this thing from pretrial because you won't be on bond anymore, so they aren't in charge of it. Oh, so I just included here and Mr. Warrensley, I don't know if you have to actually update her bond because she's technically not on bond when she's on the late sentence. So maybe not.
Okay.
Do we have a date 60 days out for this file? August 12, 8:30. Actually, can we move that up a week?
Okay, Ms. Foy is in a position to pay today the restitution as well as whatever fines and costs have been assessed. So I don't know that we will need the 60 days.
The agreement was a delayed sentence, so I don't know. I put the 60 days on there because we had to come before the court, so.
Understood.
Change it to 30 days of delayed sentence, but I feel like I have to comply with the terms and conditions. There has to be a delayed sentence for the dismissal. I don't think we just dismiss it today. Okay, 30 days. July 8th? 8:30, okay. And that will be the date that, if the prosecutor is satisfied, I would expect a nollie by then. I guess if I received it. Just a dismissal before then, of course. But again, as this case came through the court, all the money has to be paid through the court, which means there may be a delay between your payment today and their receipt of their restitution payment. Okay. But of course, if we have it and we know it's going, we would of course tell her that.
Can I write a check or does it be a cashier? How does it?
Will the clerk's office take a check, David? Do you know? I can't remember.
I believe, let me double check. I believe so. Let me go double check. So they said they won't take personal for us.
Okay. Cashier's check.
Let me.
We don't want to touch the court. Or do I see it to you?
MCR 9.120A requires your notification to the grievance administrator and the system board of conviction within 14 days. I think we're done on the record with this. It's just Mr. Wormsley trying to figure out if, what
said-
form of payment you need to bring
Yeah,
back.
they'll take cashier's check.
So,
Thank you.
Thank you.
all right. And we set it for July 8 as the deadline based on your representation that you can do that ASAP because you just want to be done with us.
Thank you.
Thank you.
I take it down with